I'm going to give a relatively brief answer, and I'm going to talk more about just strategy, and the importance of understanding a little bit about how the patent office is organized will be helpful in crafting your strategy, your prosecution strategy, and how you go about procuring your patent from the patent office. After you apply, after you submit your patent application, you end up getting assigned an examiner. So you get your application is given a serial number and it's assigned an examiner. Typically, it takes 2 to 3 years. But assuming it undergoes its normal process, your application is assigned an examiner. Now, the examiner ultimately doesn't get to have the final say in whether or not your application is patentable and whether or not your claims are merit and a notice of allowance. But they're essentially the gatekeeper. So they're the ones that have to do the search and that are going to do the initial examination and are going to try to identify prior art that might be problematic. Okay, but they have supervisors. Okay, so a patent examiner has what's called a supervisory examiner, and the supervisory examiner manages many patent examiners, and it's ultimately the supervisory examiner whose sign off the patent examiner has to get. So if your objective is to win over the patent examiner so that they can get sign off from their supervisor and enter what's called a notice of allowance on the record. Once you have a notice of allowance on the record, that means that the claims as pending on the record are deemed allowable. And if you merely pay the issue fee and complete a notice of allowance form, then your patent application will issue into a US patent. Now, the patent examiners also do another really important thing, and that is they make sure that your application complies with all the formalities set forth in the regulations. So, in the context of patents, the regulations are 37 CFR, and also referred to as the Code of Federal Regulations. And these are the rules that the Patent Office has adopted and that satisfy the patent statute 35 USC. So, the patent examiners are also going to look for informalities, but ultimately the structure and why the structure is important, why some understanding is important for you, is that you want to make sure that at the end of the day you understand that the patent examiner has to make a case to their supervisors in allowing an application. So remember that the ultimately claims are what get examined, and the claims define the meat and bounds of your invention. So they define the scope of your invention. And so again, for patentability purposes, your claims have to be novel and non-obvious over the prior art. So the patent examiner is going to have to make their case to the supervisor. So there are a couple of strategic points that come into play here. So one thing that you have to understand about patent examiners is that they're extremely busy because they have a large caseload. Okay, so anything that you can do, and especially using pictures and diagrams to communicate the claimed invention, is all that is going to be very helpful to you during the prosecution process. So if you can streamline in any way their work, that is something that you need to consider, because A, they're so busy, and B, if they can do things on their end to speed up prosecution, the more quickly you're going to have an issued patent. So a term that people often use is compacting prosecution or compact prosecution. Now, in order to compact prosecution, you need to have the examiner on your side. So you need to have a US patent examiner that's willing and sees things from your perspective in order to further along and advance the prosecution process and make it go more quickly. So what does this mean in reality? So in reality, what this means is, one example would be, let's say that the examiner cites prior art in an office action. If you can come to an agreement, and this is by phone, by email, or through an examiner teleconference, but basically, if you can come to an agreement and an understanding as to a claim amendment that would get around the prior art and render your claims patentable, then the examiner might agree to enter what's called an examiner's amendment. And the examiner's amendment is a great tool because it's huge in terms of time savings. You don't have to do anything affirmatively on your end. They're essentially agreeing, the examiner's agreeing to enter the amendment on their end. And so you get to completely sidestep you having to prepare an amendment. So if you can get the examiner on your side, and it's possible that you might be able to compact prosecution. And importantly, again, as to the structure of the patent office, it's helpful to understand that ultimately they're the ones that have to make the case to their supervisors. So it's extremely helpful if you understand that, and if you also understand the fact that they're extremely busy because they have a very large docket. And so anything that you can do to help them streamline the process will also help them. Now, another important thing to understand is that they have a point system. So they actually get points for entering notices of allowance. And so anything that you can do to help them streamline their process and further and advance the prosecution process, the better it makes them look. So that's another key thing to remember. So they have a docket and they have a system on their end that tracks all the cases that they're assigned and all the cases that they have pending, and essentially cases that they can move to notice of allowance, that gives them points. And so understanding that structure as well, so their compensation and how they're appraised by their supervisors, is incredibly helpful. The few key takeaways from a strategic perspective that will help you in procuring patents is to understand that, one, that patent examiners have supervisors. So one thing you might consider that I haven't mentioned before in this program, but one thing you might want to consider is when you have an examiner teleconference, see if the examiner supervisor can be present. Because if you can get sign off and guidance and feedback from the supervisor at that stage, then it's possible that you can really speed up the entire process. So keep all these things in mind as you are navigating the patent system and at the patent office, and having a better understanding of how it's organized, how supervisors manage patent examiners. That's all going to help you in crafting your strategy, because ultimately they need to get as many cases either allowed or finally rejected as possible. And you're not going to get a patent unless you help them, unless you help the examiner get sign off from their supervisor.